Hello, everyone. So I'm just going to begin sharing my screen to put our usual slides up there. Till, hello. It's been a while. I hope you are doing well these days.
Well, I'm fine. I'm in quarantine, but it's not too bad.
It's good to see you. And I hope that before too long, it will be in person again.
Yeah, absolutely. It's quite a while. You're right.
Though I must say these 2 years have passed at an incredible speed. I'm mentally still somewhere around March to May 2020. And it's true. Actually, when I'm typing my slides, the date on the slides, if I don't focus, it comes in as 2020 every time.
It's like a time shift.
Hi, everyone. Hi, Tilly.
Hello. Hi.
Welcome on board. I hope you are doing well.
I'm okay. How are you?
Good, good. Doing very well. The last couple of days, we've seen springtime appearing in Japan finally. So
Nice.
it's beginning to feel nice. How are you
I got
doing?
an article the other day that Japan may actually finally open borders again for students and business people after March. So fingers crossed.
I truly hope so. Our main challenge right now is probably that the booster shots are very slow. Once we have the booster shots, it would appear that the threat from Omicron is dramatically reduced. So we should have them around March, and then I'm guessing the borders will be hopefully opened. At the moment, for those who don't know, when you come back to Japan, you have a 10-day quarantine if you're not on some type of expedited entry. And for many foreigners, they're simply not allowed into Japan at all at the moment. Right. Before we get started on this webinar, which is going to be about one of the most exciting topics, Netfilter and the Patrick McHardy settlement, I'm just going to show our antitrust policy notice. We show this at the beginning of every meeting. And the purpose is to make sure that everyone is aware that we have an antitrust policy and how to find it on our website. If you're from a Linux Foundation member company, you can ask our counsel, Andy Updegrove, questions about the policy. And if you just generally want to find out more, you can, of course, email me or another Linux Foundation representative. Right, now that that formal bit is over, we had a webinar last year with Armine Hemmel, who I see is on the line as well, about the Patrick McHardy cases. And he gave us some of the historical picture on how Patrick McHardy worked and what happened. The big news in the last couple of weeks has been that Netfilter have settled with Patrick McHardy and effectively put an end to McHardy's actions as a copyright troll in the context of Netfilter, at least. Now, Till Yeager from JBB has been deeply involved in the case on the Netfilter side and can provide us with, of course, no secret details of the case, no secret gossip, but Till can provide us with insight into what happened and what it means from his always accurate, occasionally dry, and meaningful presentation style. Till, I'm going to hand over to you. You can present your slides as you wish. And, for everyone else, don't hesitate to jump in with questions and so on. We're very fortunate to have Till here today. Not only is he probably the most experienced open source lawyer when it comes to compliance and courts, but he's also quite simply one of the most knowledgeable people in our field. Right, Till, with that, over to you.
Thanks, Shane, for the friendly introduction. It's really friendly. I have no slides, but I want to tell you a little bit about the background of this settlement and the court case which led to this settlement. I see here a lot of people. I know some of you are very familiar with what Patrick McHardy did. Some people might not. So I will give you a short background information about what happened in the past and why there was a lawsuit against Patrick McHardy. So first of all, I'm a lawyer involved, as Shane mentioned, therefore I'm not neutral. So don't expect a completely neutral explanation of what happened. But of course, I try to explain the facts and not so much opinions. The background of the case is enforcement of the GPL and the lesser general public license by Patrick McHardy. Patrick McHardy is a former maintainer of the Netfilter project and started around 2012 enforcing GPL and LGPL with regard to software for which he claimed copyright, sometimes co-authorship, sometimes other kinds of authorship. And these programs are well known to you, I guess. It's a Linux kernel. It's IP tables, which is a user space program for configuration of the firewalling with regard to Netfilter, which is the part that is within the kernel, but also other programs as BusyBox, IPRoot2, and LibNL. And in this enforcement, which for a few years was not very public, people felt that the kind of enforcement was not fair. And so, of course, what is fair copyright enforcement? You can have a long dispute. I do not want too much discuss what is right and wrong enforcement. As some of you know, I'm representing Harald Welter, who did enforcement himself before Patrick McHardy, and I think most people were fine with the style of enforcement. So this was public, you could see what happened, and in particular, there was no monetization within the enforcement, and that was one of perhaps the problems, or at least what people called a GPL or copyright troll, that Patrick McHardy received a significant amount of money from real or pretended or assumed violators. And the usual way of enforcement was checking firmware updates in the internet, looking whether or not Linux is used in it, and sending a cease and desist letter. Well, that's more or less, that's okay. And it's done compliant with German law. But the problem was when people signed such cease and desist letters, because there was no intended violation. They felt, okay, it was perhaps sometimes a lack of knowledge or other reasons, sloppiness, whatever could be. And in such cases, we have seen a lot of follow-up enforcement by Patrick McHardy, because under German law, the typical way to fulfill claims to cease and desist is a declaration to cease and desist with a penalty clause. And Patrick McHardy looked for further violations, said, oh, I found on your website 25 firmware updates, all of them without a source code offer. It's 25 €10,000 penalty, altogether 250,000 euro. And of course, that's no fun for, let's say, at least companies who are willing to comply with GPL and LGPL, but perhaps have problems with the compliance system. And later on, he changed a little bit the enforcement style. So we have seen very high claims for reverse engineering costs. This is something Armine can tell you more about that. We think that these costs he claimed for were not appropriate, very high lawyers' costs. This kind of enforcement has a significant impact on the Netfilter project itself. So even after Patrick McHardy was not part of the core team of this development project anymore, there has been significant disadvantages for the project because unfortunately, people thought it's enforcement by the project and not by a single person. And since the kind of enforcement was not well seen, the Netfilter project did not receive any funding anymore, no invitations to conferences and the like. So for the people there, the situation was really unfriendly, and so they complained with Patrick McHardy, but at that time it was around 2015, 2016. Patrick did not respond at all, and for that reason he was suspended from the development team, but he continued to enforce and did not speak one word with his co-developers and the people from his former project. And for that reason, 3 developers or former developers, that is the current maintainer, Pablo Neira Ayuso, and Harald Welte, a former maintainer, and Josef Kadlicek decided to take legal action against Patrick McHardy for the following reason. Now I have a noise, so thanks. Under German theory, if you pay a penalty, the penalty is not just
suck my dick, suck my dick, fuck.
My goodness, we just had a trawl. They're reported.
Perhaps you can mute him. For that reason, in legal theory in Germany, the penalties are not just to avoid future violations, though that's one reason to pay a penalty, but the second one is it's also a lump sum damage for past violations. And for that reason, Pablo, Harald, and Josef claimed, well, if you have received significant amount of penalties, and these penalties are also damages, then you can not just take this money just for yourself, but you have to share it with your co-developers. And that was a starting point to try to put pressure on him, not so much because they want a share of the money. That was not the goal of that lawsuit, but the goal of the lawsuit were to make enforcement unattractive, because if you have to share all the damages or penalties, then the risk is lower that this is a successful business model. And though the complaint was filed in December 2020, and in 2021, the lawyer of Patrick McHardy sent the defense letter, and in the defense letter, he claimed, oh, Patrick McHardy stopped any enforcement because he's so happy with the compliance status, so there's nothing to do anymore, and he's bored or not interested to do all this hard work in favor of compliance. Well, whatever the reason might be, of course, that was exactly what we wanted to reach with this lawsuit. And so we asked the lawyer of Patrick McHardy, if this is true, what you're saying, why not settle? Because that's exactly the goal of the lawsuit. And it took more than half a year of negotiations, or better to say non-negotiations, because Patrick McHardy did not answer his lawyer neither. It took quite a while, but in the end, we managed to settle. And I guess you have read the settlement document. In a nutshell, the outcome is that Patrick McHardy cannot enforce alone anymore his rights in the Linux kernel and the Netfilter IP tables programs. So not all programs are involved, but most of them. So for BusyBox, theoretically, he could still enforce. The reason is that Harald and Joseph and Pablo do not have any rights in BusyBox or LibNL, so this is why the settlement is focusing on the Linux kernel and Netfilter IP tables, which are the most important programs here. And so nobody of these 3 or 4 parties, better said 4 people, can enforce him or herself alone, but it needs a decision of the then current core team of the project, a majority decision. And if the majority says we want to enforce, then it's possible. Otherwise, it's not. And for all the attorneys here in the group, the most important part is section 2 of the settlement. So the settlement has a third party effect. So if, although he settled, Patrick McHardy would try to enforce against any third party, this third party could defend him or herself with this settlement. So to be honest, I do not expect that we see, at least for the Linux kernel and Netfilter IP tables, any further enforcement from Patrick McHardy or involving him. Yeah, that's in the nutshell the most important outcome. And I know that many companies received cease and desist letters. So even though you have already signed a cease and desist with a penalty clause, this cannot enforce anymore without the consent of the core team. So I think that is a very helpful outcome for the whole community of companies using Linux in their products. Yeah, and of course I'm happy to answer your questions if there are any, but I'm sure there are.
So you can ask your questions by audio, or you can type them, of course, in the chat. First note we have is from Katharina, who's sending congratulations.
Thank you. Yeah, of course, that's mostly the part of Pablo, Harald, and Joseph who made that possible. So it's up to them if you want to applaud.
Dave Marr, I saw you unmuted. Do you want to jump in?
Yeah, thanks, Shane. Thank you, Dr. Yeager. This is certainly a huge piece of news to understand, and it's a great achievement. I was wondering whether or not you could comment a little bit about the theory of joint copyrights. My read of the settlement is that you didn't have to make that assertion. And so, there is no precedent here as to whether or not co-contributors to a project are in fact joint copyright holders. Is that right?
Yeah, that's correct. So within his enforcement letters, Patrick McCarthy claimed to be a co-author of the Linux kernel and Netfilter. But let's say apparently the term co-author is differently understood in Germany and countries outside the European Union. But apart from that fact, we already always disputed that fact, because co-authorship at least under European or German law, means that you have to develop the software according to a common plan. And mostly, as you know, software development is made by modifying already existing programs. So it's more kind of creating a derivative work. We have similar rules for co-authorship and development of derivative works, but it did not matter, and the settlement is covering both. But there's no anything about the court saying it's co-authorship or it's not. That's outside the scope of the settlement.
We have another question in from Yari asking, in what jurisdictions does this settlement apply? And after that, we've got Armin and Hendrik, but Yari's question first.
Yeah, there's no limitation at law, but in the past, we have never seen Patrick McHardy acting outside German courts or basing his claims on German law. So I would be surprised if he's doing that, but this is a general rule, and so I would say it's not restricted to one jurisdiction. His lawyer claimed that he moved to France, but he never provided his address there, so we don't know if this is true or not. But I have never heard about any enforcement in France or other countries.
Thank you. Armin noted a question I already know the answer to, but perhaps not everyone knows. Can old settlements be reversed or penalties be claimed back from McHardy?
Well, that's not the scope of the settlement. So you cannot claim penalties back for the reason that the settlement says so. You could claim it back if there's fraud or something else, but you would have to provide evidence for that. And so I do not expect that this is something companies could enforce. With regard to old declarations to cease and desist or old settlements, I would say at least these settlements are not enforceable with regard to Patrick McHardy, let's say with regard to penalties, because this is excluded by the settlement. Though there is a certain effect on old settlements, that does not mean that they are void or other provisions are wrong or that you can recover what you have already paid.
That makes a lot of sense. Now, Hendrik has his hand up. Hendrik, over to you. And after that, we'll go back to Yari.
Sure, thanks, Shane. And Till, yeah, thank you for this gift to the open source community. Well done. We've been involved in several cases, as you know, also with regard to BusyBox. And so I'm just wondering how this could be used, just given the case, a BusyBox case would be coming up again. I mean, you can always argue towards both sides of the story, so to speak. You could say, okay, this is proof that to some extent, now he has been tamed by the community, which is a good argument in order to refuse respective claims with regard to BusyBox. On the other hand, one could say, well, that's why BusyBox is excluded from this settlement. How's your view or position on this? What would you think, or how could one argue in this case?
I have one question back first. Do you have ongoing cases?
No, not.
Okay. So perhaps I give an answer that is a little bit broader than what you just asked, because to help you and other colleagues for future cases. Perhaps you have seen in the settlement, there's one case that is excluded from the settlement before the Hamburg cases. These two cases are completely independent from our settlement here. And there is already a court decision. I was not involved in that case, so I cannot tell you about any details there. But to my knowledge, Patrick McHardy lost that case for the simple reason that he was not willing to provide his actual address. So in the future, if you would have a BusyBox case or any case, the first point to look at is there a valid address? Otherwise, apparently German's court would say you cannot enforce without providing an actual address. So that's more a formal reason, I agree. Second point is we have never seen a court decision or a court accepting that he had provided enough evidence for his copyrights. So it's true that he was a maintainer for Netfilter IP tables. So it might be probable that there is copyrightable code that he provided or that is still used. If this is also true for BusyBox, might be much more difficult for him to provide evidence for. So this is definitely something you should look at. And altogether, yes, the settlement does not involve BusyBox, but not to explicitly exclude it from the scope, but for the reason that the plaintiffs in this case have no rights in BusyBox. And so there was no reason or no possibility to include BusyBox within the settlement. It does not say anything about the legal situation around BusyBox. But frankly spoken, I do not expect really to see enforcement in the next time. So McHardy really stopped, to my knowledge, enforcement in 2020. So the last year we haven't seen anything, and so I'm quite optimistic that this will be the case in the future as well. Whether or not this settlement goes beyond this concrete situation of Patrick McHardy and the Netfilter team and the actual scope of the settlement, that's a really good question. I would say, at least for Germany, I think it's getting more and more difficult for single developers to enforce, at least as long as you're one of many co-developers. And whether or not courts would refer to that settlement, I cannot say, but I would expect that future enforcement is quite restrictive. And if it happens because not just one, but at least a few developers decide to enforce. But that's my personal opinion. It's not based on a strictly legal reason. It's more on facts or factual situation and the observation that courts are very hesitant to enforce GPL and LGPL for one single person.
Thank you.
I have a brief addition here on. Yari came in asking about whether this would apply to other copyright trial cases about McHardy, which you have addressed. But there's, I guess the question which you've touched on is whether other potential trials would be discouraged. And it sounds like if the courts are hesitant to allow individual plaintiffs to take action, in Germany, it's now proven in a court of law, the answer would be that potential trials would not be encouraged to pursue the same path in the same legal jurisdiction as McHardy. I know that's speculation, but that seems to be a reasonable understanding of the outcome and implications.
Yeah, at least for project with many copyright owners, as this is the case for the Linux kernel. Here, I would be very surprised if single developers would enforce. And of course, it's different to say who is a troll, so that's very difficult to define. But as I mentioned, to my impression, courts in Germany are quite hesitant because they have seen quite a bit of trolling, or at least enforcement that seems to direct to monetization instead of license compliance. But yeah, we will see.
We have another question in from Martin. Is there anything specific in German law which triggered Patrick McHardy to select this jurisdiction?
Yeah, there's a lot specific in German law. First of all, it's quite cheap to enforce. Secondly, it's quick if you go by preliminary injunction proceedings. And third, we have quite a lot of case law of successful enforcement. And therefore, it's easier, or it was easier in the past to convince a court if in doing it more or less the same way as already done. I think that's specific to German law. Yeah, and perhaps I should mention that Patrick McHardy had the personal contact to his lawyer and easy access to legal representation might be also a reason for that.
Now pausing, does anyone have any additional questions for Till?
Now, I think there's one from Steve. Yeah.
Asking
if there's only one copyright holder, if that makes any difference. Of course, if you are the only copyright owner of a program, be it a company or be a single person, of course, that makes it not more difficult to enforce your rights because you're the only one. And if you can show that you're the only one, then the situation is completely different to the one that is we have seen here, because here Patrick McHardy, even if you do not look into the Linux kernel, but just to Netfilter IP tables code, you had around 250 people providing commits to the project. And if you are one of 250 copyright owners, then this makes definitely a difference if you do not involve them in enforcement.
Question from Yari. What about projects with a CLA? Does that have an impact on how things can unfold?
No, that's a question for Katharina. There are different kinds of CLAs. There are CLA with a transfer of copyright or at least transfer of exclusive rights. Then you would have one single right holder who can enforce, and there are CLAs where you only provide non-exclusive rights, and then you are one of several copyright owners.
Cool, till you're hired.
Right. Do we have any further questions for Till? Martin, are you aware of any cases where the licensee, the end user, enforces the source code offer instead of the copyright holder?
I haven't seen that in Germany. In Germany, we had one case where somebody claimed that a derivative work can be used under the GPL without being licensed under the GPL by the copyright owner. So that does not work. But yeah, somebody mentioned already that Software Freedom Conservancy is enforcing in the US. Such a case, I have not, I'm wrong, I have seen one case, to be honest, which is not public, but who failed for other reasons. There was not very well enforcement. So it was a single customer without enough legal backup. So this is perhaps not representative.
Robert has jumped in with a question. Is it known on which ground McHardy was starting his actions? Like the findings of his components inside an SBOM or his name in the copyright statements? Is it known how he started his cases?
He was well aware of the GPL enforcement of gplviolations.org. So Robert, if you have a look at that webpage, you can see what happened in the early 2000s. And because that enforcement was done by Harald, and Harald was also one of the developers of the Netfilter project. So he was aware about the current situation of enforcement in Germany. Why he started himself, I cannot say. He did not contact Harald for that reason or anybody else. So it was by his own, and most people think it's for monetization, but we don't really know what made him starting. But to find out violations, he made a very simple way. He looked just into firmware updates he found in the internet, and to look with grep or other software programs that find symbols in the binary. It's very simple. So there's no SBOM needed. There are no copyright needed. Mostly this was just firmware updates without any additional information. Just looked into the code to verify that Linux is used, and then he said, where is the source code offer? Where's the license text? And then he sent a cease and desist letter.
Now, would it be accurate then, building on that, to say that he was using quite a basic technique compared to what he could have deployed, so that people should not count on future challenges appearing in the same methodology he used? Someone might use a more automated process to look for copyright that they can litigate around.
He could have found much more cases. So it was not that kind of professional enforcement you would expect from a trolling company, for example. It was just, we had always the impression, not spend too much money. If they're easy fruits, low-hanging fruits, he took them. That's more that kind of impression we had. So of course, it's quite simple to find, in particular for Linux, to find out where there are violations. I think violations, clear violations, without any source code offer, without any license text. This kind of violation is quite easy to detect. So definitely the outcome of the settlement is not that you have not to take care about free software compliance. The outcome is that there is a person that used enforcement for personal monetization is not in the play anymore. But of course, still you have to fulfill your license obligations. You have to think about license compliance. That has not changed.
Thank you very much. We have another question or a point from Giovanna. She says, thank you for the presentation, and has a question. Is transformative fair use an exception to copyright infringement in Germany, like in the US? For example, the Google versus Oracle case.
No, we do not have a fair use exception under European, at least under EU copyright law. But we have a list of exceptions, and is a very short list of exceptions. The most things you need a license for.
Brilliant. Till, you have covered a huge amount of ground on this webinar. Thank you very much for your time, and thank you to everyone who dialed in. This is your last chance if you want to ask Till a question live, though of course you can approach Till and myself later by email. All right. On that note, I think we wrap it up. This has been one of the most important presentations that we've had in quite a long time. We've been waiting for the McHardy situation to be resolved, and it appears to be closed now. And this knowledge will be carried forward for a long time, I think. Again, as we end, as Till pointed out, this is never about avoiding license compliance, and indeed we've seen very positive and active compliance through, for instance, Harold Velte's work. We have seen great progress in the industry. In fact, we have ISO standards like OpenChain precisely about making sure that we do the right thing around licensing. But McHardy is a cautionary tale of someone taking the very openness of open source and trying to manipulate it in a way that is negative for the entire field. Till, what you've done and what your colleagues have done in addressing this case and what Netfilter's team has done is exceptional. Thank you for that, and thank you for being here today.
Pleasure, thank you.
Right, everyone, it's time to go to our respective homes, and very shortly, you'll be able to share the recording of this webinar with your colleagues. Take care, be safe, be well.
Thank you, bye-bye.
Thanks, bye-bye.
Bye-bye.
Goodbye.